Hello, and welcome to this Policy and Practice seminar hosted by the UCL Department of Political Science and School of Public Policy, jointly with the Center for U.S. Politics. My name is Colin Provost. I'm an associate professor in the department, and I'm your chair this evening. The title of this seminar is The U.S. Supreme Court and the Future of Administrative Law. The current conservative supermajority on the U.S. Supreme Court has a chance to reshape American law in a dramatic way. One such way is in the realm of administrative law, as members of the conservative majority have sought to restrain the powers of federal bureaucratic agencies. Much of the current debate around administrative law began with the 1984 Supreme Court case Chevron versus Natural Resource Defense Council, in which the court said that federal agency rulings should stand if they're based on reasonable interpretation of a federal law, and if Congress has not spoken directly to the issue. While some observers have predicted that the court would kill off Chevron deference, instead we've witnessed use of what's known as the major questions doctrine, which has raised the question of how far agencies can stretch their capabilities on major policy questions before having to seek new legal authorization from Congress. Major questions arose in the 2022 case of West Virginia versus EPA, where the conservative majority said that the Environmental Protection Agency needed explicit congressional consent to implement its ambitious climate policies. Similar future decisions could profoundly affect federal policy implementation and law enforcement, possibly shifting powers to state and local governments. Consequently, the stakes are sky high as the Supreme Court debates the appropriate policymaking authority for the federal bureaucracy for important issues that often go beyond American borders. And of course, there's also concerns about how much power an unelected federal bureaucracy should have. To discuss this topic, we're delighted to welcome three speakers whom I'll introduce in the order in which they'll make their opening remarks. Ilaria Di Gioia is Senior Lecturer in American Law and Associate Director of the Center for American Legal Studies at Birmingham City School of Law. Her research focuses on questions of law and policy within the U.S. Federalist structure. She's the editor of the British Journal of American Legal Studies, as well as the Inaugural Philip Davies Fellow of the Eccles Centre for American Studies at the British Library. Rachel Augustine Potter is an associate professor in the Department of Politics at the University of Virginia. She's the author of the award-winning book, Bending the Rules, Procedural Politicking in the Bureaucracy in 2019. Professor Potter also contributes to the Brookings Institution Center on Regulation and Markets and has served as a consultant to the Administrative Conference of the United States. Jim Tierney was the Attorney General of Maine from 1980 to 1990. He currently is a lecturer at Harvard Law School, where he teaches classes on state attorneys general and has directed the Attorney General Clinic. Previously, Professor Tierney was the director of the National State Attorneys General program at Columbia Law School. Since his time as Maine Attorney General, he's consulted with serving state attorneys general and the National Association of Attorneys General. Tonight, each speaker will speak for about 8 to 10 minutes. We'll then have a panel discussion for another 10 minutes or so, thereabouts, and then we'll open the floor to questions. If you do have a question, please raise your virtual hand and I'll call on you. And you can unmute yourself if you like, or you can write your question in the chat. You can write your question, I should say, in the Q&A function as opposed to the chat as well. Okay. As a final note, before I hand over to Ilaria, the whole session, including the Q&A, is being recorded and will be posted online on the department's website and our YouTube channel and our podcast after the event. If you speak, you'll be heard in the recording. If you don't speak, you won't. We'll let you know when the recording is available, and we hope you might want to share it with others. Okay. And on that final note, I will hand it over to Dr. Di Gioia.
So, good evening, everyone, and thank you, Dr. Provost, for inviting me to speak today. So first of all, when we talk about the rise of the administrative state, we talk about the doctrine of administrative deference. Dr. Provost has given an excellent introduction of the case of Chevron that actually expanded then administrative deference and the power of agencies to interpret statutes enacted by Congress. Now, this is just a quick clarification before I start. Chevron deference is not the only existent deference in the US. There is another type of deference, and that is our. Don't get confused between the two. Our is deference to regulations that are enacted by the agencies themselves. Today we talk about Chevron and generally speaking about administrative deference to statutes enacted by Congress. So first of all, a quick overview of why administrative deference. So the use of agencies' regulatory power is at the basis of the modern administrative state. Agency and administrative offices such as, for example, the Environment Protection Agency, the Department of Education, they do issue regulation and enforce laws. Now, Congress doesn't have the capacity to pass laws that address those complex issues. And this is actually the reason why we see agencies increasingly issuing regulation. Just after the Civil War, with the expansion of the United States, with the expansion of the state in itself, then agencies have seen their powers to grow from this point of view. So therefore, what happened? Congress doesn't have the capacity to pass those laws, and therefore delegates to agencies that are staffed with scientists, other specialists, the power to craft regulation that address those problems. So think about, for example, air pollution, COVID-19 exposures in workplaces, drug testing, the disposal of nuclear waste, and so on and so forth. So the expertise that is found in the agency is often needed in order to implement those policies that are dictated, of course, by Congress. To give a clear example of administrative deference, think about the Clean Air Act. In 1963, Congress ordered that the Environmental Protection Agency should have regulated air quality standards. So based on that authority, the Environmental Protection Agency has started issuing regulations that are often life-saving. So think about, for example, air pollution, think about chemical plants, think about greenhouse gases. So Biden, the president, has used the Clean Air Act actually to delegate this interpreting power to the Environmental Protection Agency. Of course, as Dr. Provost has well explained before, this power to interpret Congress's statutes has been challenged, and has recently been challenged in the West Virginia case. The West Virginia case gave rise to what we call the major questions doctrine, or the major questions concept. And there is a bit of a warning. We should always be careful to define a doctrine as such, because scholars sometimes disagree as to what is the point in which a concept or a jurisprudence tendency actually becomes a doctrine. So the major question doctrine has been lingering around in the Supreme Court for a decade or more, and that's finally been given good explanation, and that's finally been established in the West Virginia case. What does it say? Very simply, it says if the question is a major political economic question, if there is such a big issue, then agencies should not interpret a statute passed by Congress. At this point, and since this very recent decision of the Supreme Court, there are two main issues that I would like to put on the table and discuss today with the audience. The first question that I have is, where will these major questions doctrine fit within the American administrative law, and in particular within the Chevron framework? So far, for 40 years, we have been used to the Chevron administrative deference, and we've been used to the two steps as explained by Justice Stevens in the Chevron decision. Two-step process, usually when the courts consider a case involving the interpretation of a statute by an agency, the courts usually should ask themselves two questions. The first question is an assessment of whether Congress has already spoken to the precise question. So has Congress already given a direction, guidance? And the second step, the second question that the courts ask themselves is whether the administrative agency interpretation is reasonable. So we've been used to these two steps with Chevron, then another case, Mead, and it's spelled M-E-A-D, added a so-called step 0 to those two steps. And actually the step 0 is when the court should inquire, before going to step 1 and 2 that I mentioned before, whether there was congressional intent to delegate the interpreted power to the agency. So the courts were already facing, let's say, quite a complex mechanism to resolve issues of interpretation of statutes enacted by Congress. So we said we had Mead, step 0, step 1 and 2 of Chevron. When I ask where will then the West Virginia case sit, I'm asking whether will it be a step 0, 0, so will it come before the step 0 of Mead, or will it be a step 3? Will it come therefore after the Chevron 2 steps? In other words, if that is the case, will it be incorporated within the Chevron framework? Will the major questions doctrine become part of the Chevron framework, or will it be, and perhaps this is what I believe what happened, a completely different framework, parallel? Will it be living a parallel life with Chevron, and therefore will there be cases in which Chevron will be applied, and will there be cases in which West Virginia will be applied? But then at that point, the question is, how do we decide in which baskets does each case fall? So this is actually the first sort of issue that the West Virginia case, the major questions doctrine ruling, poses. The other question, and again, perhaps we don't have yet an answer on this, but it would be useful to speculate on what will happen, is what will the states do with the major question doctrines? The state courts in particular, will they follow the approach of the Supreme Court, or will they derail from that? I think that those are very, very interesting questions, and I would like to discuss them with you, to speculate on the future of administrative states or administrative deference in the United States. Thank you very much.
Thank you, Ilaria. Now to Rachel.
Thanks, Colin, and thanks for putting this panel together. This is a topic where we're just really unsure what's happening right now. And so it's useful to get our heads together, I think, and kind of puzzle through what might happen in the administrative state, given all of this like giant uncertainty and chaos. So I'm going to talk about rulemaking, which is a space where we might see some of these questions get answered in the next couple of years. So rulemaking, if you're not familiar with it, is a process that agencies follow that at the end of it creates binding law. And so the way it works is that an agency like the EPA, the Environmental Protection Agency, will write a proposal. They'll say, we want to make a policy change on, say, climate change. And they'll write out the proposal and publish it in the Federal Register. So anybody can go and look at what the EPA is thinking at that moment. And then there's a public comment period. So that public comment period is a time we hear about these rules, because lots of interest groups are weighing in and they're saying, oh, we like this part, we don't like this part, but anybody can comment. If it's a big rule, like climate change rules we've heard a lot about in recent years, there's millions of comments that the EPA gets. So they get millions of comments, and then After that comment period, they read through them and they weigh in. Do we want to do these things that people are suggesting? Why or why not? So they take that, they deliberate, and then they write a final rule. That final rule is a policy laid out in the Federal Register that says exactly what the agency is going to do. And it comes with a preamble that explains why or why not they're doing the things that people ask them to do in the public comments. So following that, there's a waiting period, and then the rule takes legal effect. Now, this is a very long process, can take many years. And at the end of it, right, we have binding law. So there's two important points about rulemaking that are really, I think, salient to this conversation. One is that these are laws that carry the same force and effect as if Congress had legislated in this area. So unelected bureaucrats making law. And we know that about 90% of new laws in the US are created through the rulemaking process and not through the legislative process. So that's an important point. And then just the volume and scope of rulemaking. So I mentioned climate change rules, but we see rules on everything. What is an organic piece of fruit? What counts as organic? How should your pension plan be? What is the default option when you enroll in a new pension plan? What is, can an employer make you sign a non-compete contract when you start a new job? These are all questions that are resolved today through rulemaking and not by Congress. They're important questions that affect people's lives, but agencies are deciding them. So you can see why when the courts are saying maybe the administrative state is taking over a little bit of this role that Congress should be playing, rulemaking is the place where we might really see the tensions and the conflict play out. So I want to think about, well, what are agencies going to do in light of all this uncertainty? But before I do, I want to pick up on a point that Ilaria also made, which is that Congress is part of this story. We're talking today about courts and the executive branch, but Congress is really the party indicted by the courts here, right? Congress has not answered major questions. It has left them for agencies. Congress has delegated a lot of authority to the executive branch. And the question is that appropriate, right? And so given this rebuke, can we expect Congress to kind of step up to the plate and start answering major questions? And I think the answer is clearly no, for a couple of reasons. One is the problems we're talking about that are likely to trigger these court challenges and threats. They're wicked problems. They're the hard problems. Congress gets 2 years to solve hard problems. That's it. Right? Every 2 years, we have a new set of people coming to the bargaining table in Congress, and it's hard to do that quickly to fix climate change or healthcare. The other thing we know about Congress right now is that we have an era of extremely high partisan polarization. So not only is it hard to solve problems in a short time window, we also have two parties that cannot agree on consensus about how we should solve problems. So what does that mean? It means when we get new statutes that might address some of these policy issues, they have ambiguity in them. That ambiguity is sort of the price of having the system we have. And who has to interpret that ambiguity? Right now, it's agencies and the administrative state. And I think it's going to continue to be that. So given the agencies face threats in issuing rules, and Congress is going to keep probably giving them that authority, what can we expect agency rules? How should they might differ in light of all of this uncertainty? Well, I think one thing we can expect to see is that agencies are going to start playing defense a lot more. So those rules that they're writing, when they have that preamble that says, here's why we're doing what we're doing, we can expect those to be a lot more defensive, a lot more explaining why what we're proposing is not a major question. It is in keeping with past practice and really laying out a case for future litigation that is probably going to come their way. So that's one thing we can expect. Another thing we might expect is if you're facing a lot of legal challenges and a lot of uncertainty, then you're probably going to put a lot more lawyers on the case. So most rules are written in program offices by people who know a lot about organic products or pensions, but we might see a lot more staffing up of agencies by lawyers, right? Because they need them. And that has lots of implications for how we govern, right? Lawyers think about the world in a particular way that's different than public health officials or people with other substantive backgrounds. The final thing we might see is just a lot, even more slowing of the rulemaking process. It's a slow process already, but what we're doing is putting a lot of uncertainty on top of that to a set of agencies that don't want to be the example case of what is a major question and don't want to see their rules overturned because they're so costly. So a slowing of the process that's already slow is not a great outcome for anyone, I don't think. The last thing I'll say before turning it over to Jim is I don't think we're looking at a 30-year proposition to resolve all of these questions. This is much more on the immediate horizon. So agencies are actively writing rules right now. They're writing ambitious rules, like I can point to the Federal Trade Commission, which has a lot of rules that are very ambitious in nature and have invited lots of conversation already about are these major questions that the FTC is asking. And so I think the court is going to be hard pressed to ignore this for very long. So sooner rather than later, but I'm curious what others have to say. So I'll stop there.
Okay, thank you so much, Rachel. And finally, we'll hear from Jim Tierney.
Sure. Well, our previous two speakers are going to have a great more insight into all of this than I am, but I'll do the best I can. The first caveat is one that my wife gives me all the time when I come home ranting and raving about all this stuff. She'll say, there you go, thinking like yourself again. All right. We all think like ourselves again. We reach out in our own lives and our own intellects to try to find something that makes sense out of something that may be impossible to make any sense out of. So I think Rachel's correct. I think that the agencies will continue to do what they do. I hope so. They'll lawyer up a little bit more, which may or may not protect them, because the status of the law now is clearly untenable. The law now allows any of our 673 federal judges the unfettered discretion to decide what they consider to be major. I mean, there's no standard here. This Justice Kavanaugh in his, in his one of his dissents in his hearing said, well, major kind of depends on what you think, whatever the judges make up. That's not even all the judges, of course, it's just 5 judges. So the lack of predictability is the exact opposite of administrative law. The whole point of administrative law is to take statutes which are inherently vague or not precise. I've drafted enough statutes to know that you kind of leave them vague on purpose because you're trying to get the bill through. You're trying to get it through, right? So you leave it vague on purpose, and then you know that rulemaking will come in and provide stability for everyone, and everyone will play by the same rules. That's the basic principle. So if you don't want to play by the same rules, this power gives immense authority. You have the capacity to pick and choose a lot of your 673, which judge you try to get to. That's another whole issue. And then when you get lucky, if you're trying to invalidate a rule with a judge, they can issue a nationwide injunction. Now, we talk about major in terms of a lot of money. It's not necessarily a lot of money. We're saying major questions doctrine taking over the gun regulation issue. We're seeing it obviously taking over the abortion issue. We're seeing it in President Biden's school loans. And we're seeing it in a way that many of us just can't predict. I just posted in the chat, for example, the state treasurer of Utah pulled funds out of what they call ESG investing, environmental investing, because he feels it is Satan's plan. All right. He thinks that Satan is what has not the banks, not all of us where we make our investment decisions, but Satan's behind this. As a matter of fact, he might consider this entire exercise that we're in this evening part of Satan's plan because we're even discussing it. So when you're dealing with elected officials who are living in just a world and in a parallel universe to those of us who are committed to administrative law, the ability to get predictability is very, very difficult. And that's where I have to believe that the Supreme Court, who clearly had no idea what they were doing, none at all. They do that a lot. A bunch of law professors, right? They kick these things off, they make these decisions, and then they sit back and see what happens. And so I think we're in a position where we're going to see potentially some serious economic dislocation as a result of these. Major industries will say, we don't know how to make a car. right? We don't know how to make a truck. We don't know how to build a road. We don't know how to do any of these things. If one of our 673 judges decides that somehow they've exceeded a federal law or a federal regulation that may have been enacted 25 or 30 years ago. We're seeing this in guns a lot. We're seeing rules struck down by federal judges about something which we've all lived with years. So that lack of, it seems to me that if the Supreme Court grows up, basically becomes a little more mature and understands the implications of what they're doing, they're going to have to scale this major questions back. And there's many different ways they can do that. They can change the rules of standing. They can tighten up major, what they consider major from the top. But right now we're in a high level of uncertainty, very high level of uncertainty. So what I would advise is that agencies just keep doing what they're doing and hope lightning doesn't strike and someone gets mad at their particular regulation. It would usually be someone who contributed a lot of money to somebody, usually through dark money. The whole major questions doctrine has been dreamed up through, it's not really a doctrine, it was just dreamed up in the last 4 or 5 years by some major so-called think tanks in the States. We have these rules where you can start think tanks. You don't have to say where the money comes from. So that it just appeared like in the last 4 or 5 years. So it's kind of, it was mentioned in a couple of decisions in the tobacco case 25 years ago, and passing in the ACA case maybe 10 years ago. But basically, it's a new doctrine. So I don't know. Colin characterized the judges as conservative. This doesn't sound conservative to me. Conservative means being stable, means going on the same direction. Obviously, it's heightened by a liberal administration in the States, the Biden administration, using using rules to, for example, the Federal Trade Commission. I think Rachel's completely correct. There are a number of rules that are pushing the boundaries, and so that's where we're going to see the immediate hit back. But we have an unpredictable situation. States, I'm supposed to be an expert on states. Essentially, states do not have the internal capacity to do really big national extensive rulemaking, probably with the exception of California, maybe 1 or 2 other states. California is perfectly capable of taking their own laws, drafting their own regulations, avoiding the federal courts altogether. And because California is such a big player in the marketplace, drive the entire national marketplace towards their standards. We see that in the environmental area in California. But for the vast number of states, they can draft rules based on their own state statutes, and I don't see any change from all this major questions doctrine. People at the state level will generally ignore it. But those won't be the big cases you're talking about, the climate change cases, or the big manufacturing cases, or the privacy cases, or the labor cases. But there I go, thinking like myself again. Dawn?
Okay, thank you very much. Thank you very much to all three of you. I have there's a few questions that come to mind with all of these insightful comments. I suppose, Rachel, I was most struck by what you talked about with agencies playing defense more. And you've written extensively already about, I guess, agencies kind of playing offense and defense, right, with the procedural politicking and the ways in which they're strategic in order to get rules passed. You mentioned that they might lawyer up more, which Jim also mentioned, and that maybe they'd be more careful about the language. Can you be, and this can be for all three of you, right? Can you be more specific about what you think some of these additional ways of playing defense might be? Like what else, if it is about the language they use in the rules or that sort of thing as well?
Sure. So, I mean, imagine you're an agency, you're writing a rule, you have good reason, hopefully, to do this, right? And so you're investing all of these resources in it, and you do not want to be the exemplar, the one who's like, this is what a major question is, right? And so what are you going to do? So I think longer preambles, as I said, is probably something we didn't expect. And I was really thinking about, as I was saying that, a paper by Ricky Revesz and a co-author where they talk about recommend that agencies start talking about what they call regulatory antecedents. So really in their rules, talking about how what they're proposing meshes with past practices of that agency, right? And so you can see this as like the law professors at work, right? This is 2 law professors writing. So that's one thing we can expect. I also think we might think, if you're an agency, right, there's no like unit of a rule. A rule is what you make it. It can have 37 different parts, right, that kind of work together or kind of don't. It can be like omnibus in that sense, or you can parcel it out, right? And so we've seen there's been some scholarship on like, when do agencies break one policy into like 6 parts? Right. And so if you're an agency and you're like, I want to do this big thing, but I do not want to provoke the courts, can you do it in 3 smaller parts? And then it's sort of 3 pieces that in toto makes a big policy, but in piecemeal parts is actually not really going to draw as much attention to what you're doing. So that's called regulatory bundling. Like you can bundle or unbundle as you see fit. There's no standard for what needs to be a rule in terms of the policy content. And so that's very much possible. I think we also might see agencies pointing to things like committee reports from Congress, right? So committee reports are, you can stick anything in a committee report and the whole chamber doesn't have to vote on that report. And so there's a lot of language that ends up in committee reports that agencies traditionally have leaned on, but you might see them pointing to that more directly in their rules to say, no, this is what Congress wanted us to do, see, and asking Congress, can you put that in the committee report, even if you can't get it in the bill? So things like that, I think, are kind of how we might see some of this play out.
Rachel, it's a classic example. I think it was a brilliant exposition, but it's also thinking like yourself. The people who are opposed to this are libertarians. They don't care what's in the committee report. They don't care what they just don't want government at all. They don't want it at all. So you're exactly right. So you go a bunch of liberal law professors citing them, and they say, well, maybe if we do it this way, hedge it that way. That's all really good advice, but you never know when lightning's going to hit your rule. And it's the lack of predictability, as I see it, which is just nuts, right? I mean, you're trying to figure out how to build a car, right? Are they going to go back and say, well, you don't need airbags anymore because some federal judge says you don't? I mean, I don't know, right? Are we going to change, the way tires are made? We can't tell, because it's also retroactive and it's in the hands of such a diverse bunch of judges. And we're really seeing this now in guns. We're really seeing this in abortion. People really rolling back and saying, well, the FDA was wrong 20 years ago or 25 years ago. They were just wrong. How do you know that? Well, because I'm a federal judge, I know that. I mean, that's crazy making. But what you're saying is terrific. I mean, it really is excellent. I hadn't heard it exposed, so clearly and so well. And that's what agencies ought to be doing, should be doing. That's all excellent advice. And will it work? Who knows? I think the ultimate question will be less the life expectancy of the rule as it is the life expectancy of the justices who are making these decisions. That's the only way a lot of this is going to change.
Ilaria, did you want to weigh in on that question as well?
No, I will leave the floor for the next question.
Okay, well, so coming right to you then. And so Jim talked about the state level, as we'd expect, and he talked about California's rulemaking capabilities and how that might drive things. And California is already known for being able to drive a lot of standards nationwide. You talked a little bit about what would happen to the states and what the state courts might do. Did you want to elaborate on that, as well as maybe what Jim was talking about in terms of some states being able to drive a form of like state level rulemaking process?
Sure, and perhaps James can also come in at some point. So, of course, we have to differentiate here between states. Not all states have the same weight. How will state courts rule, and how will state legislatures respond to this? So we haven't had many cases so far, but we expect, for example, the Wisconsin Supreme Court to take a different path than the federal court, or at least there have been signs that make us think perhaps the approach would be different. However, this is, as some commentators have said, this is a case that has been perhaps revolutionary, and we don't know yet what the consequences of this revolution could be. as I said in my talk, one of my main concerns was whether the West Virginia, where the major questions doctrine will be able to live in parallel with Chevron, and what is then the place of Chevron. So in other words, states have been used, to continue using the Chevron deference for 40 years. Where will Chevron go? I mean, is this really an overruling of Chevron, or will this continue to live in parallel with Chevron? I think that this is a decision that the states court also will do. And the decisions also will I think, focus on again, what is the issue at stake. So not also about states, but what is the issue at stake. So the major questions doctrine only will cover major issues, big political, big economic issues that usually are those issues that Congress have not been able to resolve because of the deadlock in Congress, because of the increasing polarization in Congress. So again, will the doctrine be relegated only to those big, important issues, political issues that Congress has not been able to resolve? Will there still be space for Chevron administrative deference? I think that this is the question, and many states will respond in different ways. According to their ideological leaning, of course, as well. So we mentioned California. I think California is a great example, but is also in some ways an exception because it's one of the biggest states, one of the states that has much weight, and you cannot really compare the weight of California with the weight of other states. So on one hand, really, I think that we should be watching how will not only the states deal with this, but actually the jurisprudence of the Supreme Court will lead on those.
Well, I've been a proponent for 25 years and had absolutely no luck on multi-state rulemaking. There's absolutely no reason at all why the states themselves could not sit together and inform it. And I think most state courts would continue with Chevron deference. You know why? Because there's nothing wrong with Chevron deference. Nobody's got a problem with it, except the extremist voices. Certainly, the business community really doesn't mind Chevron deference. They're comfortable with it. They make a lot of money. They don't really want to get involved in all this. But if you were the multi-state rulemaking, maybe I'm fantasizing here, some states would accept it, some would not. But by the very nature of how things are sold and marketed today, it doesn't take many states to drive the national market. So there is that solution. It's sort of a Rube Goldberg sort of solution. It's kind of, piecing everything together. But in terms of major is not necessarily big economically. Major is going to be big in the eyes of a beholder. The business community does not like uncertainty. They want stability. That's how you make money. You have stable rules. They don't want this. But there's always one businessman who can say, what if I just break the rule everybody else is living on, make a lot of money, and if I get the right judge who says it's a major question problem from something that Congress passed in the Clean Air Act, 45 years ago, I may make a bunch of money before they catch up with me. That's entirely possible. So this whole system is driving towards illegal, I would say illegal, but certainly out of culture behavior by businesses who drop to the bottom line. The ones who really are always on the edge anyway. I'll say, well, I've talked to litigators. Let's throw the major question doctrine in, when government comes after me. Why not? Right? And so how do you keep the cases from being removed from state court to federal courts, another whole legal doctrine? The Supreme Court could tighten up their mistake in several different levels if they understand it's a mistake. And they might if their business community friends kind of explain some basic rules to them. But if you're dealing with ideologues, then you're part of Satan's plan. So, I can't do much of that there.
Can I add just one quick thing that I happened to check out on the Wisconsin Supreme Court reaction to the major questions doctrine. So there is actually a quote here that I wanted to read out loud, and it says, I lost it. now. Okay. So it says here, the Wisconsin Supreme Court has called the federal decision eminent and highly persuasive, but not controlling. So I think that this is the approach here. On one hand, state Supreme Courts feel the pressure and the weight of the federal Supreme Court inclination, but on the other hand, states have their own constitutions, and their own constitution will deal with their own states' issues. So it would be really interesting to see how the different states' constitution will be stimulated and used to respond to the challenge. Thank you.
Thank you, Ilaria. I should say that if people want to start putting their questions in the Q&A box, they can do that if they don't want to verbally express their questions, but I'll start doing that in just a moment. I realized that Mike Liverite had asked a question before, and maybe this is for you, Rachel. He asked during the presentations, doesn't the legislature have a period to prevent any agency policy from going into force now? So why do they need to reaffirm any policy that the Supreme Court opposes?
Yeah, so clear? I saw this question in the chat, and I love this question because so what Mike is referencing is the Congressional Review Act, which is a law that says after agencies go through that whole process, they write a proposed rule, they get comments, they get to the final rule, they send it to Congress, and Congress has a period where they can basically say, nah, and they can do it pretty quickly procedurally. The problem with that is that it's subject to a presidential veto, right? And we just saw this with Biden. So it's not a unilateral overturn by Congress. So that's a thing to note about it, but I don't think that really answers Mike's question, which is like, wait, Congress can already weigh in. If you did something we didn't like, we could stop it, right? And just to point this out, Congress has lots of other tools that they can use to stop a rule. They don't have to wait all the way to the rule is finalized, right? They hear about the rule during the public comment period. Believe me, if it's a controversial rule, interest groups are reaching out to their members of Congress. Members of Congress write letters to agencies all the time. They request briefings. They do all this kind of stuff. So they are not checked out on these big rules at all. So the question is really the right one to say, wait, they have oversight already. Why do we need the courts to come in later and say this shouldn't have happened? And I think what this question sort of underlies is that idea that we have an optimal design. We do not have an optimal design. This is poorly designed. Like institutional designers should like shake their heads and be so frustrated with the way this is all working, because this is oversight, and doing it in this post hoc way through the courts is not a really good way to design good public policy and good oversight by the legislative branch. So this is, as Jim said, there's an agenda here that's very separate from the actual policies in question, right? It is a question about the role of power and how it is allocated across the three branches. And it is completely divorced from whether like the Congress likes this labor rule or this whatever rule. It is a totally separate question. And I think that the question is right to be asked, but it sort of misses the point that we're like talking politics here rather than policy.
Okay, thank you very much, Rachel. I'm going to go ahead and ask if anyone would like to ask a question. I can't see all the different people in the boxes right now, but you can either write your question in the Q&A box or just raise your hand if you've got a question for any of the panelists. If not, I will keep asking my own, which are that. Okay, Robin Taylor, you have a question. Would you like to unmute yourself?
Given the degree to which rulemaking power has to be delegated to agencies rather than Congress, and given the difficulty of Congresspersons adequately scrutinizing the volume of rules that the agencies create, how great is the scope for regulatory capture of these agencies by various groups, and what measures exist to prevent it or safeguard against it?
Is that for anyone in particular?
No, all panelists.
Okay. Who would like to take a crack at that?
I can jump in. So I think the question is about like Congress isn't really overseeing rulemaking as carefully as it could, right? Which I think is fair. Like we don't see Congress weighing in on all that many rules. And there's thousands of rules. There's about 3,000 every year. And so our interest groups like capturing agencies, I think that's something that, we open scholarly debate. We have a lot of research that looks at the public comment period and who writes to agencies, right? And we can tell that businesses write more than like your average Joe to an agency, which is not surprising. But even when they write, they get more of what they want. There's a lot of different studies that show that. Again, not surprising, but as someone who studies rulemaking, I can say, well, by the time that public comment period has already come about, the whole idea that we're making a policy in this area and that we're going to do a propose X rather than Y is its own policy conversation that's happening a lot of times behind closed doors. We don't have a lot of oversight or insight into as scholars, and that's where a lot of the sort of influence into rulemaking comes, and the groups that are able to reach agencies and that sort of closed door sessions, that those are the sort of groups that are more linked into the system anyway. So is there industry influence and capture? I mean, I don't love the word capture. I think it doesn't really explain what's happening. I think there's varying levels of influence depending on which agency you're talking about and which interest groups. Some of it I don't think is all bad, right? Industry knows a lot about the policies we need as a society, and the kinds of rules we need, a lot more than like my grandma does, right? Like, and so I don't think it's all like as nefarious as it might seem, but definitely there's a lot of influence from corporate commenters, industry, interest groups more generally, but I would be hesitant to classify it all as sort of like capture under that heading.
Okay, Jim or Ilaria, do you guys want to weigh in on that one at all?
I think Rachel nailed it. When I was younger, I was more concerned about agency capture than I am now. I actually have, in light of the last 5 or 6 years of the American experience, I'm kind of rooting for the civil service. I used to call them bureaucrats too. I don't anymore. I think there are a lot of heroes out there working in our civil service who are really trying to do this right. And when you see the forces arrayed against them and the pressures that are under them, I think agency capture is, I used to think it was a huge problem, and now I think less so, myself.
I definitely agree. From what I've seen with the notice and comment procedure, from a legal point of view, really, agencies, their staff and personnel are experts in their area. So yes, they can be influenced. They are, of course, subject to the industry, but they are the experts in the area. There is a reason why they are there, right? So I do see, and I do still have trust in their expertise, and actually this is the reason for administrative deference historically. It has been because the expertise was in the agency. Now the fact that has recently become more of an excuse to get rid of the Congress deadlock, and because Congress cannot pass a statute, then we leave it to the agencies to regulate. That doesn't change the fact that historically agencies have regulated because they were the actual place where regulations could have been made by experts that we don't have in Congress. So I would conclude on a positive note from this point of view.
Okay, 3 cheers for civil servants. Francesca Berda has a question. She says, I'm currently looking at writing a paper on international affairs and politics as a game. Do you see politics continuing down this path as being treated as a game, with consequences of actions being less considered and with poor accountability? Would anyone like to take that one? Jim, you were kind of addressing those issues before about consequences of the court.
I don't get the use of the word game. I mean, the existence of the planet is at stake, fundamental human rights are at stake. I don't understand game theory and all that stuff. That's just not my world. So,
well, maybe just the part about actions being less considered or with poor accountability. That's the final part of the question.
I don't say it again. Maybe you would have answered.
Just the way, well, kind of like what you were saying before, right? About you described the Supreme Court as not considering consequences in its decisions at one point.
Oh yeah.
Right?
The Supreme Court has no idea what it's doing.
Okay. Do you think that'll continue? Is what she's asking? Yeah.
Well, I think there's no reason the way they're selected that they could have any idea what they're doing. Their own personal life experiences are stunningly limited. The loss of justices such as Souter and Kennedy and Sandra Day O'Connor, justices who actually had some sort of life, may have actually tried a case, may have actually walked into a courtroom, was all gone. They're all law professors and superbly ambitious people who really, with one or two exceptions, woke up, walked out of the cradle and said, I wanted to be a Supreme Court justice and I'm going to hedge every remark. I see that my students all the time, they're always hedging their remarks. They're afraid to speak up because they're, the really ambitious ones. So as a result, the idea they get all these amicus briefs, Lord knows if they read them, they can't possibly. So they hire clerks just like them, just like themselves, younger versions. And so they don't understand. They have no idea. When they made the abortion decision, I think cynics say, no, I think they actually believed, oh, well, now it's back to the states. That's preposterous. I mean, that's not how we live, right? The guns, oh, well, we're just going to go back to the rules in 1805 because, Alexander Hamilton sent an email to James Madison after drinking a little Madeira and said, we should do it this way. I mean, these are preposterous rulings. The idea of a country of 350 million people would be governed by people making these decisions. They just don't know. So hopefully they don't live complete isolation. They're all here in Washington with me. Someone will talk to them about some of the devastating impacts because of the instability this brings to the business community. I mentioned that earlier, and I think it's really important. You're getting ready to invest hundreds of millions of dollars in something, hundreds of millions of dollars, and some federal judge somewhere is going to just throw that all up in the air, and the judges can say, well, after it's fully appealed and briefed, I'll take a look at that in 3 years. That's not how the business community works. That's not how corporate decisions are made. And so I think the biggest force for stability in all of this will be the business community itself, markets itself. People will say this is getting crazy out here. And it will overwhelm all of our well-meaning briefs and memos and theories that we lay out. And that happens. I mean, you watch, look, major questions doctrine was invented 8 months ago, really. It could disappear 8 months from now. They could say, it changed my mind. 5 of us changed their mind. It's such a good idea. I mean, that's how they live because they have these lifetime appointments, sort of like tenured professors. They have these lifetime jobs that they really have no consequences for what they do. And, that could happen. I'm not optimistic, but it could happen.
Okay, thank you, Jim. Ilaria, go ahead.
Can I add something on this? So on one hand, James, you say they don't know what they're doing, these 9 Supreme Court justices. On the other hand, it seems to me that perhaps they know very well what they're doing in their crazy ideology. Because, when I think about the 9 Supreme Court justices and the criticism around the power of the Supreme Court to strike down acts passed by Congress, this superpower of judicial review. On one hand, I think about, for example, Chief Justice Roberts' decision in the Sebelius case. I think that he knew really well what he was doing there. He was trying to strike down part of a big healthcare reform in the United States and to let survive another part of the reform. So he did know very well what he was doing, and he had been very creative in the way in which they decided to uphold the healthcare reform. So I think that on one hand,
your example proves my point. If you look at the Sebelius decision by Justice Roberts, you see that he really wrote on the other side. And then he went home at night and said, this is crazy. Billions of dollars have been invested. I can't do this. Right. So, but it took, I didn't mean to overspeak.
Anyway.
But I mean, it proves the point that it took that kind of astounding ability to get some sort of reality to somehow sink in. And when I say they certainly understand their ideology, they certainly are all excited about, how guns were regulated. We got a judge who just said there's nothing illegal about scraping serial numbers off of handguns, because when the Second Amendment passed, no guns had serial numbers. I mean, this is crazy making, right? And so this is the problem of thinking like yourself. I mean, this is nuts, right? Why would somebody take the serial numbers off a handgun? It's because it's illegal and they're going to shoot somebody. That's why they're doing it. And so everybody knows that. Congress knows that. The ATF knows that. That rule's been on the books for 20 years. But they say, well, let's look back and see. Maybe we should change it. So you're correct. If the influence gets overwhelming, the justices might, but they do not understand the full implications of how the rest of us live, right? They do not know what it's like in our town. They forget the fact that when they get in a car and they put a seatbelt on, that seatbelt's there because of government. And there's an airbag in that car. That airbag is there because of government. They have forgotten that. Thrown into this sort of, the justices like Alito, into this sort of libertarian mindset. They don't have any concept. They just take it for granted because they're living in this, they're driving a safe car, right? And safety provisions that were fought tooth and nail, but now they're here and we all live with them. Everybody lives the same rule. Why? Because administrative law works. Yeah.
Yeah, but on the other hand, I see this conservative majority and conservative decision really as the result of, the ideology of the last 8 years in the United States, and of the influence of the Federalist Society as well on the Supreme Court. When you just, if you search for the West Virginia decision, then Federalist Society is everywhere around that. They claim it's their own creation, actually. It's thanks to the influence of the Federalist Society that we have this decision. So actually, those justices, yes, perhaps don't know what they're doing, but they have a very strong ideological basis for doing what they do. And it's grounded in decades of conservative jurisprudence that has only arisen now in the court because we have a conservative majority.
But the American people haven't changed. Kansas votes 60-40 pro-choice. American people haven't changed, right? The American people overwhelmingly don't want to have non-compete clauses when you work at a fast food restaurant. American people overwhelmingly. So the response has been to eliminate referendums, to eliminate the opportunity for people to actually express their views. And this is replete over and over and over again. And so, so you're right, it is an ideologically based as opposed to a fact-based worldview. It's ideologically based as opposed to a fact-based. And we administrative law types, we're fact people, right? That's what we're trying to do. I love to hear from industry on rulemaking because they know so much more about how their industry actually works. It's fabulously interesting and important, and it keeps government from making mistakes. But if you eliminate the whole product by putting it in the hands of one federal judge, good luck.
I'm going to jump in and say to people, please keep writing your questions in the Q&A, or would somebody like to ask one verbally right now? I can pause for one moment. I don't see any hands coming up. So I'm going to give Rachel a chance to weigh in if you'd like to on the previous discussion that was just had about accountability and
it wasn't discussion. It was a rant on my part, and I'm sorry.
And from mine, sorry.
I think that I'll just cap off the conversation by saying I think the conversation is really highlighting. So political scientists, which is my background, I'm a political scientist, think about courts as an ideological space, which is not often. So it's refreshing to hear lawyers talk about it in that way. The court's making ideological decisions, and that really like what we're highlighting here is the lack of pragmatism. And that's like what Jim is pointing out about industry needing stability, is that there's no pragmatism to all of this. Like, how do we run a government and solve policy problems is not part of this conversation, which is really, really fine. Let's let Congress do everything. How is Congress going to do that? It's not set up as an institution to do those things. So the conversation is very much intellectual and ideological rather than like geared towards solving policy problems. And that is a huge problem. I think so.
Okay, thank you very much. More questions from the audience?
I'd like to hear from Colin.
Okay, I can give you more. So, well, one thing that's interesting here is that I mean, you've indicated that all of you have indicated to some extent that we don't know what will happen. I mean, there's some things we can see happening, but Jim in particular, you've said that business likes predictability, right? And so with state AGs and with multi-state lawsuits, one of the reasons that they've said they don't like multi-state lawsuits is because they like predictability, and so they argue for federal standards, right? Often, which is what they want. But it almost makes you wonder if this is like much ado about nothing, maybe, right? Maybe business will push back significantly and realize that there's not really a good alternative to what we have in terms of deference to bureaucratic agencies. And it's just that, you know, things will go on as they have been because there's that need for certainty, right? So I mean, you're talking about the libertarians and such and wanting to do away with things, but we can't realistically do that because businesses make things, and then there's inevitably going to be the need for certainty about rules about what they're making, whether it be organic fruit like Rachel talked about, or one of these things. So maybe there's not a lot of reason to be alarmed about this.
Oh, there's plenty of reason to be alarmed. The business community doesn't speak with one voice. I mean, we have enough self-styled individual multi-billionaires now that they can break off from the pact of what I would call the traditional Chamber of Commerce American. And there's huge battles going on now within the community trying to figure out a way to get to one voice. But the individual players who walk out, where you have one individual has $1.6 billion to give out in dark money political contributions. Astounding. It's astounding. And there are directing, by the way, the question of the state courts. You kept mentioning the Wisconsin Supreme Court, which of course is in the most bitter political election for the court right now. I posted something in the chat room on it, which could completely change that because they're focusing on the election of state judges as well. But I think there's plenty to be alarmed about because a lot of damage can get done along the way, right? I mean, major questions doctrine gets thrown into gun regulation, gets thrown into abortion regulation. There's a lot of human beings whose lives are going to be changed forever because of these sort of ideological decisions made from on high. So my view is obviously an extraordinary minority in where I work. So I wouldn't take my word for anything. There are plenty of people who have a different view.
I'll pop in here. Go ahead. That's okay. So I kind of heard Jim saying like, well, maybe like corporate America will save us because they're going to realize that there's no stability in this. And that is like a great hope and aspiration. But I feel like it's very hard to convince the CEO of Chrysler or whatever firm that things like the non-delegation doctrine really are going to bear on their bottom line immediately, right? And it's unclear, right, how any individual rule or case is going to actually affect. It might, in some cases, make them richer, right? So they might see an immediate case that's like actually going to cut in their favor, but the long-term trajectory is what we're talking about. And individual actors are very bad at that, solving that collective action problem, right? Of saying, oh, wait, we as a community are going to maybe be worse off. It's like, who's going to step in and provide that public good for that community? It's not clear, that the Chamber of Commerce is pushing in a direction against this. And so it seems like I agree that they definitely are going to be losers in the long term, but are they going to be proactive enough to weigh in now?
They're not great at long-term stuff. So yeah. You and I are in wild agreement.
Yeah.
And one more case to watch, I think, that will involve the major questions doctrine in the near future is the students' loan case before the Supreme Court. I just found the name is Biden versus Nebraska. I think that is one that will give us, I think, some answers as to what is then the direction of the Supreme Court. It seems that the Supreme Court is inclined to wipe out the decision of the agency to erase the debts of the students. And this is because of a major question doctrine issue. And that will be an absolute, I imagine all the students, with a debt expecting now their debt to be cancelled, and the reaction against the Supreme Court decision like this, that would be really a case in which then the power of these 9 justices will be clear to everyone.
Well, it will be. I think you make a good point. They might very well couch that decision in terms of major question doctrine. But what disturbed me the most, really, in that debate, and it's a legitimate argument on both sides of being able to wipe out this huge debt without any congressional action. Chief Justice kept saying, I just don't think it's fair. It's not fair that one person's loan gets permitted and another one's. And I'm thinking, hey, judge, you're a judge. Fair is not a legal doctrine. Fair is, what do you personally think is fair? And you're not a congressman, judge. You don't get to make those decisions. You're not the president. So the idea that the court has, without even, and nobody blinked on this, none of the national commentators got into this. The idea, the arrogance is so great. You give somebody a lifetime appointment, they're going to be there for the rest of their life. I think we'll go this way instead of that way. That's not judge making. Right? That's the arrogance of an institution itself, which is constitutionally granted this extraordinary non-reviewable power. So they may very well put it in major questions, but they just could sit down and say, I know, let's sit down with their spouse and say, hey, honey, I just don't think that's fair. Let's do it another way. Who are they to do that? Believe me, I'm telling my grandson, he better get ready to pay off his loans. I'm going to tell you that. He's not going to get a break.
Well, Jim, you mentioned before that maybe another path to predictability is if judges realize, okay, that this is, the consequences can be too much, right? You invest billions of dollars and then something gets overturned, right? And you mentioned standing at one point. Now, the standing issue doesn't seem to have gotten as much. I mean, it's gotten some, but not as much media attention in that case, right? Because you have Nebraska apparently arguing on behalf of Missouri in the student loan case, right? So I don't know if that's just like a fluke, right? An accidental thing, but or maybe it's a pathway to standing issues becoming.
All the law professors talked about standing before that argument. They were lined up 10 deep in every law school in the world saying, oh, Nebraska doesn't have standing, which I think they clearly don't. So often that they had to argue in favor of Missouri, it was all crazy making. But when they got to the argument, judges didn't care about standing. They said, we want to decide this one because we don't think it's fair. That's not a legal standard. That's just what I feel like doing today, right? And that's no way to guide a country, And I think the same thing with guns. I don't think they seriously worry about what the law was like in 1801. They just want everybody to have a gun. So they say, let's write it up in a way that everybody can have a gun. You can bring it to church. You can bring it wherever you want to go, And then they evidently don't care about the First Amendment because they're saying that, you can bring a judge to church. And of course, what if the church wants to ban it? They have First Amendment rights. So they may start to rethink some things when they get a little bit more pushback. But I just think they do what they want. I'm sorry. It's always been my view of the court. Ever since my experience with Bush v. Gore, it's pretty clear to me that the justices just come in and do what they want. That's why there's these big fights. Everybody knows that. That's why there's these big fights, these big congressional hearings that are all laid out in all these different ways. But the bottom line, you get to be a Supreme Court judge. You get to do what you want. Kind of like the professor.
Well, and that's why Rachel and I, and probably many of us here, see courts as an ideological space, as you said before, right? So there's even prior to Bush versus Gore, there's plenty of evidence going, particularly the Supreme Court, right? Not all courts, but Supreme Court.
You could say that's from the other side. You could say the Warren Court was just making things up, just granting rights to criminal defendants because they felt like it. I mean, you can build this I mean, I'm enough of a lawyer that I can build the argument both ways. I mean, I think you're correct. I think it's an institutional creation that I believe is out of control going one direction, but I was raised at a time when a lot of people thought it was out of control in another direction.
Yes, okay.
On the political nature of the Supreme Court, I think this is nothing surprising. It is actually rooted in the way in which Supreme Court justices are nominated, right? I mean, if we do for a moment a bit of a comparison with this country, for example, with our Supreme Court judges, well, there is a huge difference in the way in which they approach a case, in their ideological background. I'm thinking about my students when I start to talk to them about judicial review in the US and the equivalent of constitutional review in this country, and they're all very surprised at the very beginning when I start telling them that there is a divide in the Supreme Court between liberal and conservative justice. They're like, okay, I don't know, first of all, the name of the UK Supreme Court judges, and I don't know what is their ideological inclination. So actually, this is not surprising. This is, I guess, also what makes US constitutional law so fascinating, so different than what happens here in Europe. It is the nature of your system, and it is really how it has been working until now. This is from actually a very European perspective of the issue.
Yeah. So, of course, UK Supreme Court judges can't strike down laws, right? And they're also they at least try to appear more neutral in the appointment of judges than it is in the United States. So, if there are, this is the final opportunity to ask questions. We haven't had many from the audience today, but if you want to ask any, this would be the time. We've had a couple of people thank.
Well, I think that's quite bad timing. We'll just we'll just wait and see if Colin pops back.
So I think we have a question here from Andrea.
Andrea, you
yeah.
should yes, please unmute yourself.
Sorry, just one thing. The Supreme Court here in England, because I'm based in England, I work in England between Hungarian and English, and mainly law, is a problem as well. I mean, they've got the same problem with politics, that it's paid by the state, whatever I do, and it's not supposed to be politically committed, but it's a big problem and it's always a big row, but they are not supposed to strike down legislation. Because we've got Parliament Supreme when it comes to legislation.
Yes, indeed. So obviously, the doctrine of parliamentary supremacy in this country forbids the UK Supreme Court from striking down any act passed by Parliament, and therefore the UK Supreme Court is much less a political institution than the US Supreme Court. However, the UK courts can issue a declaration of incompatibility with some acts of passed by Parliament. So they can refer to Parliament back.
Yeah, that's what they can do. Yes.
Yeah,
Okay.
Quite a different system.
They don't enforce legislation. They refer.
Okay. I think I froze a moment ago, and I don't know if, yeah, this is like the third time I dropped out by mistake. So, yeah, everything I read, I think was into the ether, but it was just saying that this was the final event of the term. You can follow us on Twitter and Instagram. Our Twitter handle is UCL SPP. So, thank you to the audience for being here. Thank you so much, Jim, Rachel, and Ilaria. And I really enjoyed the discussion. I think everybody else did too. So that's it. And my apologies again for my time zone flub, Jim and Rachel, but you guys handled it like stars. Okay. Take care, everyone. Thanks. Bye-bye.
Thank you.
Thank you, everyone. Thank you.
Bye-bye.